Not until sometime later, primarily in the 20th century, did people create the sort of militia-based concept of the Second Amendment. And in fact, the point of view that was so dominant 20 years ago that the Dean was discussing was not the point of view that was addressed by the city in our case. It used to be that the presidents would say, well, the Second Amendment secures the right of the state to arm a militia, the right of the state to have some sort of military unit. That's not what the city argued in this case, and it's not what Justice Stevens even adopted in his dissent. About 15 years ago or so, the other side to this debate gave up the idea of the state's right to have a militia, and instead they agreed with us now that it's an individual right. Of course, there's that pesky phrase in the Second Amendment, the right of the people, the same right of the people which is found in the First Amendment, the Fourth Amendment, the same people who have rights in the Ninth Amendment, and so on. They gave up the idea that you could possibly say that the right of the people is really not a right of the people, but somehow the right of the state. So instead they posited a new vision, which is, well, yes, it's a right of the people, but one which can only be exercised at state direction and control. And so it's a public purpose right, or a sophisticated collective right. Basically, the individual right to do what you're told by your state military unit. A difficult concept of a right, not one that has any grounding in history or the record, and in fact was rejected now in Heller for hundreds of pages of reasoning, which we can all read later. If you look at the proposals that the states sent to the Congress, the states that demanded a right to arms, it was crystal clear that they were talking about an individual right to arms. Virginia, for example, made two lists of amendments, and it's true that they made a demand to re-alter the militia powers. That is, they wanted the state to have more control over a military unit, and that was the 11th Amendment that was proposed in what they called other amendments. But in the same document, they have a list called Bill of Rights, and under the Bill of Rights Amendment, they had the Second Amendment language, and that was paragraph 17 of the proposal that came out of the Virginia Convention. So here you have Virginia proposing a Second Amendment type amendment, and also a militia type amendment of the kind which was argued by the dissent. Now, why would Virginia do the same thing twice in the same document? Obviously, these things had different meaning, and indeed, at the time, everybody understood that the militia was not going to be some club or some unit of government. The militia simply referred to those people who were capable of bearing arms in order to bring about public order or defend the state in time of catastrophe or invasion or some other problem. Because there were no standing armies, there were no organized military units, there was no calling 911, there was no sheriff's department, there was no municipal police. The fact is that people had arms. It was understood that this was a basic tool of life that people would have, and then people could act as militia using their own arms, privately supplied, when the call came out, in fact, to do so. Which is why all of the early decisions interpreting some of these, what the Dean calls the militia clauses of the early state constitutions, actually found that those secured an individual right. If you look at the early decisions of the Massachusetts State Supreme Court, the North Carolina Supreme Court, they all agreed that even though there was some of this common defense type language, some of this militia language in their state constitutional analogs, that what was discussed actually was an individual right to arms that was applied and given weight and meaning throughout the early American period by those states. I found particularly interesting the discussion of the copyright and patent clause. I actually do practice intellectual property once in a while. When I'm not doing Second Amendment material, that's the other focus of my practice. In 2003, the Supreme Court abolished any meaning that the preamble to the IP clause has. In Eldred v. Ashcroft, we had a challenge to the so-called Mickey Mouse Act, the Sonny Bono Copyright Extension Act. And for those of you who follow these issues, basically, Mickey Mouse and his friends were about to head into the public domain, which was very upsetting to a lot of large corporate interests that have a lot of valuable intellectual property that they wanted to keep securing. And so they got Congress to honor the memory of Sonny Bono by extending the terms of existing copyrights. And of course, some people sued and said, this is crazy. It does not serve the progress of science and useful art to extend a monopoly to something which was already created 70 years ago. You're not providing Uncle Walt with any further incentive to draw cartoon characters. He's been dead for a long time. And so this is not actually, not only is it not a limited time, if you keep extending time, but it also doesn't serve the purpose of promoting progress in science. And both the DC Circuit and the Supreme Court basically said, That's really for Congress to decide what promotes progress. We're not going to use that as a limiting principle in too many ways. And likewise with the term limited time. And also with respect to the telephone book case, you cannot just photocopy the telephone book. You will be sued for copyright. The information is in the public domain. That is, you can make your own phone book. That is, the Copyright Act does not protect facts or ideas. It protects expressions. So the phone book, if it's a mode of expression with a page number and subheadings and an information which is arranged in a certain way, cannot be photocopied and sold in the street. However, you can read the phone book, get that information, and make of it what you will. The fact that it's contained in a phone book doesn't mean that information is somehow protected by copyright. And that's a distinction we copyright lawyers talk about. I just wanted to clear that up in case you work in those areas, which are somewhat different. But the preamble to the Copyright and Patent Clause is not any more limiting than the one in the Second Amendment, or for that matter, the preamble to the Constitution itself. You cannot go to court and say that an act of Congress does not establish justice or secure the blessings of liberty. It doesn't work. The court said that's flowery language, it's nice, but the court has always followed the traditional way that we approach preambular language in statutory and constitutional text, which is to say that only if there is some ambiguity in the operative clause do you look to the preamble to help you interpret it. But when the words of the operative clause are clear, you ignore the preamble. And that is an ancient way of construing statutes that existed in the English Parliament, in the English courts, in the early American system, and it's with us through today. And so the right of the people to keep their arms shall not be infringed. Sounds pretty clear to most people. You don't look to see whether the preamble, in fact, alters or shapes that, although, as Justice Scalia's opinion does correctly, the two clauses are harmonious. Using ordinary accepted modes of English grammar, the first clause tells you a reason, not the exclusive reason, not the exclusive purpose, but it tells you why you have a right to arms. It's one reason. Why? Because if you don't have arms, you can't function as militia, because of course militia is composed of everybody using their own arms. And I think with that we should probably open up the questions.
I will, to the degree that I can see you from here, identify folks who have questions, and we'll have at it.
I'll start. This one is mainly for the Dean. The Supreme Court, starting in a series of cases that began in 1820, the latest one being in 1990, held that federal power over the state militias was plenary. How does that fit with your view of what the Constitution, of what you just described the Constitution? Of what you just described the role of the Second Amendment being. And one particular example that comes to mind is 1955 Little Rock, where the Arkansas governor called out the National Guard, the president federalized them, and that was the end of that story. And there was no Second Amendment defenses came up with that.
It's an interesting question I haven't thought about. I guess the first point I'd make is that when we're looking at constitutional interpretation, you can 1820s is very different from 1791. Mr. Gura talked about a lot of the early cases and how they interpreted the individual right. It's a little bit like when my son was small, he used to have the phrase "olden times." Olden times would be, he was about 3, so 4 years ago would be olden times, and when the dinosaurs roamed the earth, and that would be olden times also. I think he always thought of my life as spanning olden times. So what you can have in the 1820s with respect to kind of a broad understanding of the scope of the federal control over the militias doesn't necessarily track where they were in 1789. But other than that, I'm not familiar with the line of cases.
Well, I think it's a great question. Let's talk about 1865, because that's really when that was resolved. And the idea that the states have a right to a military unit with which to check federal power, that ended at Appomattox Courthouse. We saw that. And in fact, 2 years earlier, in 1863, the Pennsylvania Supreme Court, for a brief period of time, enjoined the Union draft of Civil War soldiers. They quickly changed their mind, which I think we're all glad of.